Please the court, counsel, my name is Christopher Reese and I represent the appellant in this case, the City of Akron. I think with 15 minutes allotted for my argument, I probably, or I know I don't have the time to touch on all the arguments that were outlined in the city's brief. So I picked a few that I'm going to address, and certainly if the court has questions on any of the ones that I don't address, I'll be glad to address the court's questions. First is the open and obvious doctrine in this case. The trial court below overruled the motion for summary judgment and found a question of fact as to whether or not the defect in this case in the sidewalk was open and obvious. I don't think that is necessarily the issue before this court with regard to the open and obvious doctrine, however. Both Ms. Calet in her deposition and the photographs that were attached to her deposition, and they're in the record, seem to at least prove, the city's position is that it proves that it was plainly obvious. The condition in the sidewalk was open and obvious. Ms. Calet testified that if you're standing next to it, you can see it. The photographs speak 1,000 words. It is plainly visible and plainly obvious to a person walking on the sidewalk. The issue with the open and obvious doctrine is, are there attendant circumstances present? Are they proven in the record which defeat application of the doctrine? The legal word is obviate. Are there attendant circumstances, and did the appellee offer evidence to prove attendant circumstances that obviate the open and obvious nature of this? There are 3 attendant circumstances that the appellee argued below and again on appeal. And I want to address each one of those. But first, an understanding of what attendant circumstances are. My reading of the many cases in the courts of appeals in Ohio that address attendant circumstances, it seems to boil down to a 2-part definition of what they are. They are something unusual that happens that distracts the pedestrian's attention or the plaintiff's attention. Something unusual that distracts the person's attention. And the second part of the definition is, it cannot be a condition that the plaintiff created or brought about. It can't be a self-imposed attendant circumstance. With that definition in mind, then, I will analyze the 3 attendant circumstances that the appellee identifies in this case. The first one is traffic, heavy traffic. I will concede that there's case law that does hold that heavy traffic can be an attendant circumstance which defeats the open and obvious doctrine. I submit to you that in this case there is no evidence on the record that there was heavy traffic that Saturday morning on Brown Street at 7 a.m. There may have been some traffic. I believe Ms. Calet testified that the traffic had begun to pick up a bit. But there is a lack of evidence in this record of heavy traffic. And that is how the traffic attendant circumstance has been defined. Second, I think that attendant circumstance fails because I don't think that the circumstances of our case are what the heavy traffic attendant circumstance doctrine contemplates. If you are walking in the street or running in the street and there's heavy traffic, and at the moment you step in a condition, it's because you're paying attention to the traffic. That's a distraction that was caused by heavy traffic. If you're walking on a sidewalk or a walk into a business and there's all kinds of heavy foot traffic coming in and out and you're trying to maneuver through that and you're not looking down and you step on a condition, at the moment that you stepped on that condition, the heavy traffic distracted your attention. However, those aren't the facts of this case. Ms. Calet testified that traffic began to pick up a bit, which prompted her to make a decision to go from the street to the sidewalk to run. When she stepped on the sidewalk in the condition on the sidewalk, there is no testimony, and she did not testify that at that moment she was looking at traffic, that traffic was distracting her attention. The traffic in this case merely prompted her decision to move to the sidewalk. Therefore, I do not believe that there's either proof in the record of that attendant circumstance, nor do I believe that any evidence in the record with regard to it meets the legal definition of attendance of the heavy traffic attendant circumstance. The second one, decision to cut through the tree lawn. I understand the appellee, Ms. Calet's position in this case that my decision to cut across this tree lawn and start running on the sidewalk is an attendant circumstance that eliminates the open and obvious doctrine. Problem, go back to the definition. You can't create an attendant circumstance. Ms. Calet made the decision to cross the tree lawn onto the sidewalk and run on the sidewalk. She created that attendant circumstance, if it even is one. Therefore, the city submits that that attendant circumstance was not proven below and cannot be proven on appeal. The third and final attendant circumstance that Ms. Calet argues is that the hole was flush with the sidewalk, and that's an attendant circumstance. But I've given some thought to that, and I think to myself, first of all, Ms. Calet concedes that the hole is plainly obvious to someone who's standing on the sidewalk looking at it, but then argues as an attendant circumstance that it's flush with the sidewalk and that somehow prevents a person from discovering it. It seems to be internally inconsistent, that argument. Secondly, as I pointed out in the brief, or as the city did, the hole may sit flush with the sidewalk, but it ignores the fact that while it sits flush with the sidewalk, the color of the hole here, white, is stark contrast to the surrounding sidewalk. The fact that it merely sits flush with the sidewalk, in this case, is not an attendant circumstance. Therefore, without the proof of an attendant circumstance or evidence that meets the legal definition of those attendant circumstances, I believe we're back to the condition remains open and obvious, and therefore there was no duty owed to Ms. Calet, and the city's entitled to summary judgment on that basis.
Counsel, before you go on, Ms. Calet has pointed out that the city's authority to appeal the denial of the motion for summary judgment is based on the court not granting immunity. And we have, case law that suggests that only the immunity issue is appealable. I wasn't entirely clear on your response to that from the brief, but if you could just spend a couple of minutes addressing
Certainly.
why it is we're looking at matters involving what would seem to be the merits of the action rather than whether or not the city is immune.
Certainly. The argument addressing that, I believe, is in the reply brief here on appeal. When you look at an exception to immunity, the exception in this case, what we call the B2 exception, has two prongs to it. It's first, you have to prove a proprietary function. In this case, the proprietary function at issue is the water distribution system. But embodied in the exception is a second prong, which is proof of a negligent act. Quite often in these cases, plaintiff's counsel believe that when they prove a proprietary function, they've proved at least a question of fact as to the exception, that they've met the exception. It ignores that the exception also embodies negligence, proof of a negligent act in this case. Therefore, because negligence is involved in it, each of the elements of negligence is therefore at issue, including duty, breach of duty, proximate cause. And that opens up the door, I guess, to argue each of the elements of negligence, including duty, open and obvious, assumption of the risk, breach of that duty, proximate cause.
So in any case in which a municipality is denied, any negligence case in which a municipality is denied immunity, the entire issue of negligence is right for the court to consider?
That's correct. That's the city's position. Because the exception embodies the doctrine of negligence, the negligence doctrine.
And I didn't recall, whether or not you cited a case for that proposition. I did read what you replied to, I just don't.
I did on page 2 of the reply brief, the city cited the two elements, which is proprietary function and the elements required to sustain a negligence action. The Pierce case, Matter versus City of Athens, Gable versus Miami School Board, that the exceptions just don't look at a proprietary function, that they also embody or they also include negligence.
Thank you.
Sure. The second point I want to touch on while I have some time is the status of Ms. Calet being a licensee and the standard of proof, which is wanton conduct in this case. Wanton conduct requires there to be proof of three things. Wanton conduct, under the definition of the Maslin case, Anderson versus Maslin, requires that there be a great probability of harm under these circumstances. I do not believe that there's proof in the record here that there is a great probability of harm with regard to this particular condition in the sidewalk. Not a possibility of harm, not that there might be might be harm involved or associated with the condition. There must be a great probability of harm under the circumstances. Secondly, there has to be proof that in the face of that great probability of harm, some city employee failed to exercise any care whatsoever. Not that they just failed to appreciate the harm, that's negligence. There has to be proof that an employee made a decision to ignore the great probability of harm under these circumstances. Again, I submit to the court that this case is an issue of proof. There is no proof in the record in this case of wanton conduct. There is no testimony that a City of Akron employee appreciated a great probability of harm under these circumstances and then made a decision to ignore the risk and failed to exercise any care. That's the definition of wanton conduct. I believe that there is not a question of fact in this case as to wanton conduct, and that the City of Akron deserves summary judgment because they did not breach the duty owed to Ms. Calet as a licensee in this case. Thank you.
Thank you. You may proceed too, you have 15 minutes.
Thank you. May it please the court, honorable members of the 9th District. My name is Michael Elliott. I'm here on behalf of the plaintiff in this case, June Calet, who is seated here in the courtroom. I know at this part of the proceeding we don't ask questions or have a plaintiff testify or an appellee testify, but this is an important matter, as I'm sure it is to the city, and June did want to be here. I have one picture of an enlargement of the hole, the access point to this water valve causing injury that I may refer to, and I'll just set it aside for a minute. I do intend primarily to rely on my briefs, but I am hoping to clear up some of the confusion that was created not only in the briefing by the appellant, but also that has been further confused here today. It sort of kind of shocked and surprised me that counsel did not devote any time to the issue at hand that Judge Moore brought to his attention. I don't know if that's a concession on the part of the city or not, but the fact of the matter is there's a very narrow issue before this court that the city is trying to expand, and that is simply put whether or not it is entitled to immunity as a matter of law. And this is not the first time the appellant has done this. This court has reminded the appellant in the past that the issue being raised in this appeal is not subject to review by this court. The only question, and I will quote Davis versus Akron, in this court stated that the only question is whether at this stage in the proceedings the city has established that it is immune from liability as a matter of law. The appellant in this case has the burden to prove that this immunity extends to it as a matter of law. If you look to the arguments, particularly the arguments raised today, these are all factual issues. These are all factual arguments. We've got to take a step back and also remind ourselves here as the plaintiff appealing a decision by the trial court that ended the case. We're here because their motion for summary judgment was denied. The trial court found there were sufficient issues of fact on all the issues raised here today that did not entitle the appellant to the motion for summary judgment as a matter of law. I think that's a very important consideration to make. Once again, it emphasizes you see appeals day in, day out, many of which are different matters, but a large chunk of those are civil matters. What you don't see is people who are denied summary judgment coming up before you asking that the case be ended, that my client not be given the opportunity to have her day in court, which the trial court found she was entitled to have. The only real basis the appellant has to challenge the court's decision below, again, it was a question raised by the court, was whether or not it's entitled to immunity. And in order to do that, you need to adopt the argument that was raised by the appellant in their briefing, that what caused Ms. Calet to fall and become injured, and I believe it was conceded here today, as a part of the sidewalk. You are going to have to rule and issue a decision that this forms a part of a sidewalk. And I think that's probably why the issue was sidestepped here today, because common sense dictates that it does not. Not only does common sense dictate that it's not, but the appellant couldn't cite to a single statute, ordinance, regulation to stand for the proposition or the position that this is a sidewalk, this forms a part of the sidewalk. You can be sure that the appellant, a major city in Ohio, if it had some basis to make that argument, you would be hearing from it. There was some Ohio Basic Building Code regulation, health code statute, sewer or water statute or regulation or ordinance, they would be citing to that. But there's no basis of authority. In fact, the authority is just the opposite. In our briefs, we cited the case law that found that conditions that dealt with or involved equipment for purposes of water, sewer, if they just so happen to be in the sidewalk, that doesn't necessarily inure to the city's benefit and make that a condition of the sidewalk.
Well, how do you respond to the city's argument that in order to decide the issue under B2 of the exception and whether that applies, that we have to, as the trial court did, look at whether or not there was negligence, and in looking at negligence, we have to consider all the elements.
I would respectfully suggest at this stage in the proceedings that is not part of the process of review. But if you do decide to do that, you first have to decide that this is in fact a part of the sidewalk. You can't jump to that part of the analysis. That part of the analysis was the back of their brief for a reason. You first have to decide the issue as to whether or not this is, grants immunity. You can't go to that stage of the issue at this point in time. If it were, that would mean every time they're denied summary judgment, they could come up and appeal the decision, which is in effect what they're trying to do with this case. Now, they cited to the public duty doctrine, and I believe, with all due respect to opposing counsel, they've abandoned that position. Simply no longer exists to the extent that that doctrine still has some viability, doesn't concern individual acts of negligence. Fully 2/3 of the brief and all of today's argument was devoted to affirmative defenses, which you just pointed out and raised. These are all issues that are left to the trier of fact. Counsel has indicated that there were inconsistencies within the position. I would respectfully disagree with that. I would suggest that that was a mischaracterization of my client's testimony. But to the extent that there are inconsistencies, that's not something for this court's determination or review. That is something best left with initially the trial court, and then once the trial court's made that determination, with the jury. Once again, we don't believe open and obvious. I could have brought further pictures. They're in the briefs. It's in the testimony. This was not, according to my client and others who have been out there, an open and obvious condition. Simply was a very bad condition, and there's a mountain of evidence and testimony in the case that points to the fact that the city was fully aware that this condition existed well before June's injury. And as a result of that, we believe this is a case that has merit, that immunity doesn't apply, and that it should be properly before the court. We would respectfully ask that this case be sent back down to the trial court with further instructions to that extent. I understand the need and the reasoning behind allowing in these rare circumstances for an appeal to be taken. This is an injury that occurred almost 4 years ago now. And certainly we didn't want to be up here in front of you once the trial had taken place arguing issues of immunity. Thankfully that won't happen at the conclusion of this matter. But in some rare instances, it's not fair that June should not have her day in court and that this should extend this long. So we would once again respectfully request that the matter be returned to the trial court with no just delay or reason for further delay. I would at this point be happy to entertain any further questions that the court has.
I don't believe so.
Thank you, Your Honor.
Thank you. You do have 5 minutes. You said you didn't want it, but you do have 5 minutes if you so choose.
Sure.
Never known an attorney to turn down an opportunity to talk.
I hope I addressed the court's concerns about how the issue of negligence is before the court, because that issue it was raised in the Davis case, and I want to answer for the Davis case because I addressed that in the reply brief. And what the Davis court said was that we recognize that we are confined or constrained to an immunity analysis alone here. So the question then becomes, what is an immunity analysis? What exactly is this court? What is that analysis? And again, I reiterate, that analysis is two-pronged. That analysis is there proof of a proprietary function in this case, and is there proof of a negligent act of a city employee? In closing, I want to address the negligent act of a city employee very briefly. There seems to be some confusion as to whether or not there needs to be a proof of a performance of an act here or an act or omission. I submit to you that the statute, the exception, the B2 exception in this case reads or requires that there be proof of the negligent performance of an act, not an omission. What is alleged in this case is
I
an
would
omission.
object, Your Honor. This goes beyond what was addressed either in the direct or my rebuttal.
I understand, but really there's no objection, but I understand what you're saying. I'm going to go ahead and let you proceed.
Sure. The city submits that there must be proof of a negligent act of a city employee in this case, not an omission. The statute does not read omission. In the Hill versus Urbana case back in 1997, this Ohio Supreme Court included act or omission in its syllabus, and that's been cited over and over again that somehow the Ohio Supreme Court in that case expanded the statute. I submit to you that the Ohio Supreme Court did not do that. That is what the syllabus reads, but there are other courts of appeals opinions in this state, the 7th District, and I cited the Puffenberger case out of the 8th District, which has decided, and I urge this court to do the same, it has decided to construe this exception narrowly and to search for and demand the proof of the negligent performance of an act rather than an act or omission. What is truly at issue in this case is an omission, and that does not fit the language of the statute. Thank you.
Thank you. Thank you, Counsel. Gentlemen, thank you both for your presentations to the court, and the court will take the matter under advisement